It's a big question in people's minds as to how lawsuit protection applies to their own personal residence. First of all, you need to understand that if a person has a lot of equity in their home and they are in especially a high liability business, I can understand why they stare at the ceiling at night worrying that if they get into the mother of all lawsuits, that the lawsuit might actually end up taking the equity out of their home. But first of all, let's talk about something that might make it where you might sleep a little better. Every state has what we call homestead acts. Homestead acts are part of the code, the statutes in that particular state, that is designating as to how much of the equity in your home can be taken in the event that you are involved in a major lawsuit. The problem is that most homestead acts don't do a very good job of protecting much equity. Some states it's 20,000, some 5. There's 2 or 3 that don't do any. You have some that are 50, even 100, and in some cases, under certain circumstances, 300,000. But you should note that there are at least 6 states that make it so that pretty much your average lawsuit is not going to be able to touch your home. That's South Dakota, Texas, Florida, Oklahoma, Kansas, and Iowa. Washington, D.C. includes that as well, but that's not a state, so I guess we don't call it a state. So if you live in other of those 6 states, and you are really worried that you have a lot of equity in your home, and you're trying to be able to take measures to protect your home's equity, you might need to consider using some methods such as limited partnerships or LLCs to be able to accomplish that goal. The problem is that we always use every means available to us to protect your home's equity before we put them into limited partnerships or limited liability companies. Here's why. Even though your home is probably bulletproof against lawsuits when you put them into LLCs or limited partnerships, you may end up having to give up some tax benefits. For example, what if you have mortgage and you're in the habit of deducting your mortgage insurance, your mortgage interest? It may very well be that the IRS will come out and say, if you put your home in an LLC, you can no longer take that. Another one is the profit that you make on your personal residence. If you have a personal residence and you sell it and there's a capital gain there, private individuals can have up to $250,000 worth of profit, and you can sell the house and not pay any capital gains taxes. If you're married, it's $500,000. There's a lot of speculation that the IRS may disallow that if you have your home inside of a limited liability company or limited partnership. So the idea is that sometimes you have to make a decision as to what worries you more, losing your tax benefits or losing your home in a lawsuit. A lot of times we'll find that people in high liability businesses are far more concerned about losing the equity in their home than they are about the tax benefits. So that's an option. Again, we use every available option. For example, some states have what we call tenancy by entireties. We have several states, not quite half, who have tenancy by entireties. That means that the only way they could take your home, if you owned a home in joint ownership with another spouse, the only way they could take it in a lawsuit is if the lawsuit applies to both spouses. And frequently that only applies to one spouse. So sometimes people will take the gamble that they're going to be able to protect their home through the tenancy by entirety statutes rather than by the limited partnership. But either way, that kind of gives you an idea about how we handle homeowners' concerns for lawsuit protection.